The following is a presentation of the exculpatory factors and evidence in the case of Mcnatt versus Texas. The following sample of information has been gathered during an investigation between June 8, 2024 to January 1, 2025. The original arrest of the defendant was in November of 2016. The critical evidence used against Mcnatt is one letter describing instructions for hitmen allegedly written by Mcnatt and an index card with personal information of the two would-be victims Maravik and Mary Grace allegedly written by Mcnatt. Both were not certified or authenticated by any handwriting analysis expert at trial and were obtained by a third party, a friend named Edwin Kent. Other evidence is poor quality audio recordings of two meetings with undercover officers, which were not transcribed for trial, as an undercover officer testifies in Volume 3, page 187, that they didn't have the time, much less the money, to go pay for somebody to put all this into a transcript. But it seems they do have the time and money to try to prosecute a person and sentence them to life in prison with poor audio recordings. The police reports were not introduced into evidence, despite how heavily the court relied on testimony pertaining to these police reports, which is a violation of law and civil rights and due process, etc. Immediately after his arrest, it appears, in my opinion, the police made sure he could not defend himself with a private attorney by seizing his property at his home. It is not known if they had obtained a proper warrant, as they have refused to disclose records, but the Pasadena police came into his home, photographed various items, and broke into his safe, Volume 4, page 49, Volume 1, page 8, and seized many gold coins, jewelry, family heirlooms, and cash, estimated to be valued up to $100,000, which were not involved in the alleged crime, nor were introduced in trial as evidence. Thus, they are subject to release to the defendant, just as how they release his truck. But the Pasadena Police Department has engaged in evasive tactics to prevent the defendant from getting his valuables, and delaying the disclosure of even the most basic records the defendant is entitled to under law. The defendant only managed to obtain the police report when the Attorney General got involved and demanded Pasadena disclose the record. Now, Pasadena will not answer their phone in City Hall, their legal department, records department, or the property room, or come forward to the property room window, or call the defendant back, or respond to emails. Internal Affairs Sergeant Kenneth Urban has been contacted, and he no longer will respond. Calls conducted and not answered have been documented and recorded as evidence. Now the following is a summary of some of the lies, inconsistencies, and contradictions in the false testimony between the state's witnesses' facts of the case, police report, and the prosecutor, Samantha Mcnatt. The prosecution starts the trial with direct examination of McGregor. On Volume 3, page 21, Mcnatt asks McGregor if one of the officers with the Pasadena Police Department brought a possible solicitation case to his attention on November 20th or November 21st, and he says yes. But later on, Volume 3, page 34, during cross-examination under the defense attorney Tommy LaFawn, he changes his story to him being assigned the case on November 8th, which is what is stated correctly on his previously unavailable police report, page 35, also in the police report what is to be assumed as undercover officers, TN's report, page 6. He does state that on the 21st of November, we received information from Detective McGregor, but in McGregor's report, he states he contacted TN on November 19th. Police report, page 36 to 37. Additionally, in Mcnatt's opening statement on Volume 3, page 15, she states the initial tip and prompt start of the investigation was on a nondescript date in October when Edwin Kent approached officers during an unrelated police response to a disturbance. What she doesn't say is this disturbance was at his home at 30,809 Meadow Lake Road. During Kent's direct examination, Volume 3, page 44, he states the disturbance was at his house, but gives very little details on why the police were present, and then testifies he showed the police text messages and a letter and a note allegedly written by Mcnatt. Further, during direct examination, Volume 3, page 44 of Edwin Kent, he testifies he came forward in November. And during cross-examination, Volume 3, page 65, Kent also testifies that he was buying time as instructed for detectives in September. And in Volume 3, page 66, he elaborates. He did it because of Thanksgiving holiday break. And obviously Thanksgiving is in November. Kent, miraculously, is not held in contempt of court for this inconsistent testimony now spanning the start of the investigation from September to November, 3 whole months. This further undermines the credibility of the state's timeline. Also during cross-examination, Volume 3, page 51, Kent elaborates that the police responded to a call he allegedly made about a fight outside his front yard between his girlfriend's brother, possibly a man by the name of James Ketchum, and an unknown person who he did not elaborate on their identity or anything. Now, this is the call for service requested by Mcnatt in December of 2024, and he is being delayed and set off by the inappropriate and unlawful abuse of the Attorney General Public Information Disclosure Review process. The defendant is not at all asking for sensitive or confidential information. This is a call made about a fistfight outside a home. He only needs the date of the call and who was the two individuals fighting. It is completely unrelated to the criminal case other than establishing the timeline of testimony of the initial complainant who kick-started the investigation with his allegations. Mcnatt believes the Pasadena Police Department will not even release this simple record, as it will completely ruin the false narrative and timeline formulated by the Pasadena Police Department and the District Attorney's Office, which amounts to conspiracy. Mcnatt also believes, as he heard the story from Kent before he was arrested, that in fact it was Edwin Kent who was in a fight with his girlfriend's brother, and he injured him and was afraid of going to jail, so he made these false allegations in order to receive leniency. Also, if this isn't true, it is very odd how shortly after trial Kent was indicted for sexually assaulting a minor and only received probation, and is now a registered sex offender. Now, when record of this call for service was requested, the Pasadena Legal Department submitted ludicrous claims in the brief to the Attorney General's office. Such as what was being requested was sensitive information in regards to minors and sensitive graphic crime scene photos such as persons decapitated, dismembered, and mutilated, and information of the identities of undercover officers and information that would reveal undercover tactics used by police. These claims are false, as it was communicated that the call for service record was the main focus of the request, and they are to redact what they deem sensitive, not to inappropriately attempt to characterize the request for. The entire record, if any information was somehow confidential, it's about a fight, and they're attempting to falsely characterize the request to the Attorney General. Back to McGregor, he is further cross-examined and asked if he had any text messages back and forth with the prosecutor Connect. He answers that it's possible. And on page 35, he states he doesn't have those messages anymore and did not preserve them, further undermining the credibility of the case. It is to be noted on McGregor's police report, it has much information not included in trial, such as in page 35, he instructs Kent on November 8th, after speaking to Samantha Connect, to obtain incriminating audio recordings of Mcnatt in order to further the investigation, thus contradicting the claim by Connect in her opening statement, volume 3, page 16. In short, that the letter is what triggered the investigation. That is false, as clearly in McGregor's police report, page 35. He was just reviewing a report regarding Kent's claims filled out by Officer Riddens, and no urgency seemed evident as he didn't collect the letter allegedly presented to officers that night, just filed a concern for welfare complaint. Further in McGregor's report, page 35, he tasked Edwin Kent to gather incriminating audio with his cell phone on November 8th, and on November 11th, Kent reported back via telephone stating that he had failed to gather the recording for reasons that cannot be deciphered from the redacted police report. But he then states to McGregor that he obtained instructions for the hitmen as if it were new evidence, and as to say that he was attempting to substitute the requested audio for the letter after his failure as if he's desperate to gather information. Kent's involvement in gathering recordings is not mentioned in court record. He further testified falsely that he had no involvement in volume 3, page 50. Further on the police report, page 35, McGregor states he then contacted Connect on the failure to obtain audio, but that he obtained the letter and recommended that he could have the narcotics team obtain the audio, and subsequently Connect agreed, showing that this whole case was a conspiracy to frame, coerce, and trap Mcnatt under any circumstances after they failed time and time again to obtain any admissible evidence with proper chain of custody to establish probable cause to arrest Mcnatt. As any reasonable person would assert that if the letter and index card were not collected immediately as evidence, they cannot be proven to have been authored by Mcnatt, and they have no proper chain of custody, as the testimony and police report clearly confess the state did not properly take custody of the evidence. Edwin Kent further testifies under direct examination, volume 3, page 42 to 43, that in October-November is when Mcnatt approached him with the proposition of having the women kidnapped, sexually assaulted, and killed, and didn't take him seriously till he suddenly produced information like their names and addresses. Information for him give to fictitious people Kent invented named Samson, David, and Goliath, in order to buy time to figure out what to do, and did not contact the police immediately. And notably, as stated earlier in volume 3, page 65 to 66, Kent says a similar excuse is that in September, he pretended to be in Skype contact with these individuals in order to buy time under the instruction of detective. In cross-examination volume 3, page 63, Edwin Kent quickly changes his story that he had Mcnatt write the information under his request, contradicting his earlier testimony that Mcnatt approached him unprompted. Kent also states on Volume 3, page 78 to 79, under cross-examination by LaFawn Kent, states that he is not sure how officers made copies of the text messages between him and Mcnatt, only that he knows they did it somehow. When asked if he still has the same phone, he says no. When asked where the phone is now, he answers, "I don't know." These messages were never produced as evidence. This insane evasiveness is not addressed or brought attention to, and he is not held in contempt. On Volume 3, page 44 to 45, Kent also states he turned in the letter and index card in person at the Pasadena Police Department, meaning he had not surrendered it at the scene of the disturbance where he alerted officers. It is highly questionable how officers would not collect such critical evidence for such a serious crime and allow a man to walk away with it. Kent also conveniently does not state how much time passed or the date of when he turned the items in to Officer McGregor, and it is curious that in the police report made by McGregor, Police Report page 35, McGregor notes the date as November 11th when Kent turned over the letter only after a call on November 8th, but also does not mention any index card being turned into him, further casting doubt on this narrative and the chain of custody of the index card and how is introduced into the investigation. Furthermore, as mentioned in report page 35, he states that he had a phone conversation with Kent on November 8th, which is the earliest date accurately recorded, so subsequently at best 3 to 4 days passed before Kent turned letter, and thus the chain of custody is broken regardless and very questionable, especially as the earliest month that was stated in Kinect's opening statement of the night of the disturbance where Kent reached out to officers was October 2016, Volume 3, page 15, further casting doubt on the narrative strung together by the prosecution. Volume 3, page 49, when asked if, once he received the letter, is that when he promptly showed it to the officer and then gave it to McGregor, he answers yes. But this contradicts the aforementioned facts. It would not be possible to give them the letter promptly when McGregor speaks to him November 8th, and then he comes in November 11th. In Volume 3, page 50, Kent states that after meeting McGregor, he then contacted Mcnatt and told him that there was going to be a meeting set up between Samson Goliath and David, and he would let him know when. And then got back in contact with a detective, and he told him when the meeting was going to be and everything. And then he relayed that information to Mcnatt, stating effectively he was the point of communication between officers and Mcnatt, which contradicts his later testimony under cross-examination Volume 3, page 70 to 71, when asked if he ever had the contact of the undercover hitman, he denied, and said he never spoke to undercover officers, only McGregor. So when asked, how is it that Mcnatt ended up getting in contact with some undercover police officers in the end, he claimed he didn't know, just that he had nothing more to do with it after meeting with McGregor. But this contradicts Undercover Officer JP's later testimony, Volume 3, page 88, where Officer JP, under direct examination, states that he spoke to Edwin Kent on the phone, meaning that he had Edwin Kent's phone number and Edwin Kent had his, thus they could be in contact with each other. Undercover JPS also only states that he spoke to him about the letter, never mentioning the note, which is accurate to the police report, page 35 of McGregor, only mentioning he received the letter and processed it as evidence. In Volume 3, page 72, Kent denies ever seeing Mcnatt face-to-face after Mcnatt's first meeting with undercover officers, and on Volume 3, page 73, when asked a simple question on if he just spoke to Mcnatt, Kent slips up and admits he went to Mcnatt's house after the first meeting and that Mcnatt was upset. Once again, LaFawn does not preserve the point nor calls Edwin Kent on his blatant lies. Also on the same page, once again, Kent lies that he has never spoken to the undercover officers when asked by LaFawn, and it is not addressed. Volume 3, page 75, during cross-examination, LaFawn asks Kent if he ever told anybody that he was previously a Navy SEAL, and he answered, possibly, which is a bizarre answer. Then, on Volume 3, page 76, he states, I don't remember, but I never told anybody I was a Navy SEAL. This cast immense doubt in the credibility of Kent as a key witness for this crime, as he has been nothing but deceitful, evasive, and inconsistent with his testimony. It is notable that never in the trial was it ever mentioned that McGregor instructed Kent to obtain incriminating audio recording of Mcnatt in order to further the investigation as instructed by Kinect in Police Report page 35. The trial continued. The only other evidence is audio that is noted on the court transcript many times as garbled or hard to hear. Volume 3, page 94, 180, and Volume 4, page 100 and 5,000, 115, 118, 122. Any reasonable person would conclude it is absolutely ridiculous to solely rely on garbled, unhearable, bad quality audio recordings to convict a defendant.